What happens if both parents want primary custody?
Wait, fight to the death.
Welcome back, guys. Thank y'all for joining us here at Cases and Cocktails. This is episode 6, and today we're going to talk a little bit about child custody battles, but more importantly, the often used phrase, best interest of the child. How are you doing today?
Good. How are you?
Good. I'm fantastic. We've got a new drink today, I think.
Our cocktail today is a tropical ranch water with coconut tequila and watermelon water.
Did you do that just for me?
Yes. Well, Fernanda did.
Well, that's fair. That's fair. One of my absolute favorite drinks, tequila and ranch water, or tequila and topo. So, all right. Do that. I'm going to take those things out. It's a lot for me. All right.
She's going to be mad at you. It was really pretty.
Oh, that's fantastic. We can do that all day. All right. What'd you think?
It was really good.
All right. Let's talk a little bit.
Best interest.
Best interest of the child. Mm-hmm. We use it all the time.
We do.
We hear it all the time.
Well, ultimately, it's the thing that the judge has to say when making the ruling about kid stuff, right? The judge just has to find that the following is in the children's best interest. And then
I think the best question to be asked about this is, what the hell does that mean?
It means so many things. I mean, obviously, we've got the Holly factors. We've got a list of questions that are supposed to be taken into consideration about your ability to co-parent and your ability to provide for the child, stuff like that. But at the end of the day, I don't have many cases where the Holly factors are what I'm using to crush it in court, right? Like, these cases vary so much and the details are so different that usually if you're in intense litigation, you've got some other stuff to talk about in court.
Right. I'll tell you this. I think, so for me, best interest of the child, obviously, the court's supposed to be putting that at the forefront of making their decision. That's what it is. And if you get an agreement, the parties have to agree, right? That whatever the terms of those agreements are in the best interest of the child. Okay, that's pretty easy. I think, though, in the litigation realm, I think the thing that I often see, and particularly in my cases, are you either have you kind of have two different subsets of cases. You have the really salacious facts, right? And I was in court. I was in court the other day, and I was trying to express to the judge that this was really a best interest case, right? We were there on temporary orders, and we had mom and dad, and we were talking, and both of them were sort of fighting over 2 kiddos, and really who was going to have them, when, and where. Mm-hmm. And I told the judge, because I drew a blank. I couldn't think of the word salacious primarily. So I used the word that I typically use. I said, and judge, there's just no sexy facts here, right? And she just sort of looked at me, and I said, it's a litigator term, I get. But, it's just, when there's no sexy facts, what do I mean by that? So there's no drug alcohol issues, right? There's no physical abuse, emotional abuse. There's no neglect. There's
no psychiatric concerns.
Yeah.
It's just 2 generally good parents that can't agree on possession and access.
Right. And how does the judge make that decision? And that's really where you see the best interest is used across the board, but it really starts to play. So when you don't have those sexy facts, right, which are part of the best interest, sort of approach, mm-hmm. you've got a situation where, when you don't have those facts, the court's looking at almost everything.
Right.
And it's tedious. As we use the Holly factors, and we talk about that, we're talking about, how well can a parent take care of the kid, right?
Who is making the decisions? Who's making better decisions for the kiddos, right? And I don't envy the judges' positions, because I think that a judge making a decision in a case like that is harder than when I'm going in and proving that, the other guy is a regular meth user, right? That's kind of an easy decision for the judge,
Right.
or it makes it at least easier to start with, in my opinion. The problem is when you've got two good parents and now you've got to decide, where the kid's going to live primarily and go to school and who gets a visitation schedule. That's hard.
Yeah, that's what I was trying to tell the judge. I was trying to tell the judge, look, it's not an easy. I was trying to explain to the judge that I didn't think that the decision was that easy because you did have two good parents.
It's not clear cut.
It's not clear cut, right? And so, and the judge agrees. Like, the judge literally looked, back, particularly during the ruling, and said it is difficult, and the judge recognized that you had two good parents, and she told him, right, y'all are good parents. Y'all going to be able to do this.
What turned the decision in that case, do you think? What did the judge ultimately rely on when making the decision?
In that case in particular, that was a situation where you had the children were a little bit younger, and the judge was trying to really ensure that the kids had equal time with the parents.
Because they weren't in school yet.
They weren't in school yet, and there was some concerns about whether or not one parent or the other parent could take care of the younger child. There was a very young child, but ultimately it came down to that neither parent was saying, and I think it was even said, right, during the examination, I don't think the other parent's a bad parent.
Right.
That's not the issue. It's whether or not, this parent or that parent should have more time or less time. And ultimately, I think the judge looked across the board and said, look, they're both good parents. And when you have a situation where you're doing that, I think it's in the best interest of children to have equal time or the most time that they can with both parents.
That's a hot sports opinion.
Well, let me say this. So it's a hot sports opinion, but the statute actually sets out a policy. The public policy is to do that. Then you have another hot sports opinion which says it should be a 50-50, right? That's a different hot sports opinion. Mm-hmm. And then you've got the standard possession order that most courts follow, which is what the statute says. But I'll say this, for me, those cases when we're talking about the best interest, those cases, they're always the ones where you find yourself in the courtroom talking about, well, what's a typical day like for you with your kids?
Who helps the kids with homework? Who cooks dinner?
Yeah. And it's, you're asking those questions and oftentimes I think clients think, that doesn't, well, I do this or I do that. It's very important to be able to articulate those things because that's what those cases turn on, right? Those cases are turning on how involved are you with your kids? Are you involved in going to the doctor, making the decisions, right?
Something that I try to get the judge to focus on if I'm not on what I would consider to be the winning side in those arguments is, this is a new world. Right. Yes, traditionally, let's say, mom was a stay-at-home mom, so mom did more of the parenting and dad worked, and so he did more of the providing. Now we go into court. If I rep dad, opposing counsel reps mom. He's, opposing counsel, he or she is saying, my client's the one that's been doing this and the kids are great. So obviously it's working. My argument then is, yes, it's been working and it's great, but this is different. She's going to have to work.
Right.
Just because she didn't work doesn't mean that she can't, and she's going to have to. Right. And just because dad didn't do some of these parenting things doesn't mean that he can't, and he's going to have to. So don't just fall back on, relying on what they did during their marriage because they're not going to be married after this. They're not going to be together anymore, and you've got to give both parents an opportunity to parent, in my opinion.
Yeah.
When you're talking about best interests like that, it reminds me of a case where before I had the case, I would have thought that there's no way that a judge would ever give a kid to a parent who has actually never parented the child and who is almost a complete stranger to the child. Had a consult, and this guy calls and he says, so I recently found out that I have a kiddo. Kiddo was in elementary school. I think that the situation based on, just what he's heard at mom's is not good at best. There's some real safety concerns, welfare concerns. He said, so I want to file for custody, and on temporary orders, I want the kid to come live with me. By the way, I live in another state.
Right. So well, just real fast. So the client, when they called you, they'd not been around the kid, or they hadn't been involved with the kid.
He had seen the child once,
Okay. All right. And lived in another state.
lived in another state.
And then basically wanted to be able to go to court and get custody of the kid. All right.
So I had to give some real reasonable expectations and, tell them that, on temporary orders, obviously, if we can prove significant impairment, we can prove that there's a safety welfare concern, maybe, but this child doesn't know you and you live in another state. Like, I think that a judge would be really hesitant to just turn this child over. And on temporary orders, generally the judges will keep the status quo. So if what has been going on is generally fine, they'll keep that. And then we do the hard-hitting stuff on final orders. So we go and we do the hearing, and we're able to prove that there are some significant safety concerns and
Safety concerns with mom.
And so the judge ordered that I, as an officer of the court, was to leave the courtroom, drive to this local elementary school, meet with the principal and the child, and effectuate unenrolling the child from school, and put the kid in my client's car. And the client was then going to drive to the airport and take this child to another state. I was a bundle of nerves. I thought, this kid's going to freak out. Mom, of course, also was going to come and be at that meeting.
Right.
And
just say goodbye.
Right. Along with the younger sibling that didn't have the same dad, and there wasn't any active litigation. So we went and effectuated all of that. And, by the end of it, the police had come, and some other guy who I guess she had told was the father showed up. And, it got pretty contentious for a while, but at the end of the day, this kid went with this stranger and they flew to another state.
Well, it's not just a stranger. It was a stranger, but it was the biological dad, right?
Yes.
So it's not like some rando off the street, right?
No, but it's a guy that just found out that this was his kid. It was a scary situation for me because I hadn't known the client long enough to really get a feel for who he was. Obviously hadn't had any in-person meetings with him before actually going to court because he lived in another state.
Right.
So it was kind of a scary situation. But by the end of that case, so when the child went, there were some concerns about the child in school. They thought maybe there was a learning disability. The child didn't look like he was thriving, I guess is the best way to put it. I just got an update from that client about a week or two ago, and child is, obviously we finished the case and judge kept the kiddo there. Ultimately, in the other state, the client hired another attorney, and they ended up terminating mom's rights so that stepmom, his wife, could adopt the kiddo. The child is several grades ahead in reading, in mathematics. He's absolutely thriving, has a half sibling. The kid is doing amazing now. And I had a hearing yesterday in that judge's courtroom that had the initial hearing, and I updated the judge about it, and he was pretty ecstatic. He said that he agreed. He was nervous when I left the courtroom that day about how it was all going to play out. But, that's just an example of how best interests, when we've got two good parents in some normal situations, we talk about who's better at, doing homework or making sure they get to the doctor. But sometimes we've got some other big issues to deal with, and that can really change the lens which the judge looks through to evaluate the case.
Well, and it really articulates and highlights too. And the word and the phrase "best interest" gets used. Mm-hmm. And people want to look at it and say, well, what does that mean? And try to narrow it down. And there are factors that that you look to determine the best interest. But quite frankly, the word that controls is the D word, right? Discretion. I mean, that's it. Like, the court has discretion, and it is, as you might say, a country mile wide. I mean, it's it's wide open. And like in your case, the court has the discretion on a temporary order to send a kid to another state. And
I know in many other courtrooms, if that case had been in another county in front of another judge, that case could have turned out completely different.
Yeah.
These judges they're humans, so they have histories and they have biases, and they try to leave that at the door. But again, they're human, and it's going to have an impact on how they see and how they rule on cases, which is kind of a scary proposition.
Well, I think it is, but I think also it highlights too that, when they have, because of that, because they are human and they have that discretion, you're putting yourself in a situation as when you go into the courtroom and you're litigating these cases based on the best interest of the child. You've got to take everything into account, and you've got to really have a very succinct and well thought out, sort of presentation, right, for the court, so the court understands what's going on, and you can help the court navigate what needs to be done. That makes sense?
And I think that's why it's important to hire attorneys in your cases that have experience in the counties that you're litigating in.
Right.
Does it matter all the time? Not necessarily, but there is an advantage to knowing whether the judge has children, whether the judge has had a divorce and had custody of the kids, whether they've been through litigation, whether they've had addiction issues. I think it's all important to have an understanding so you know a little bit of the judge's history before going in and putting on your presentation.
Right. And, when you're putting on your presentation, what you're trying to do is you're trying to use the data points, right, that you get from your client that have occurred in the case to put together that presentation for the court. But the court does ultimately have discretion. And you can go to court on temporary orders, you can go to court on a final hearing, and you may get something that neither party really wanted, but the court has the discretion. And so it's like I said, it's a very wide sort of runway that the court has in order to make these decisions, and they can land anywhere in the middle. And at the end of the day, if you've got a case and it's a custody case, and you're talking about doing these custody battles, and you're talking about how are we going to put together the best interest of the child as far as it relates to the presentation, you just need to know everything from the salacious, the sexy stuff, right, to the sort of the pedestrian stuff that all gets weighed by the court, and the court ultimately gets to make that decision. Tell me real fast, you think maybe you answer a couple questions here from some of the people who've been watching?
Yeah, absolutely. So these are some of the questions that we've received either in comments or other means of social media. And oftentimes too, just questions that we have on consult. So potential clients, questions that they regularly ask.
So the first one we've got here is what are the actual factors that the courts consider when determining? So I guess what are they called? We talked to them a little bit, right? The Hawley factors. Yeah. So tell me a little bit about that.
So the Hawley factors are one of the things that they take into consideration, and that's just a whole slew of questions. The ones that I think are important that I have to explain to clients a little bit is, what is something that the other side does well as a parent? Because the reaction generally in intense litigation is, well, nothing.
Right.
Okay. Well, that's not the answer that we want here, right? And I have to explain that you've got to show the judge that you're willing to co-parent, and you've got to take a step back, put your feelings aside, and, you had children with this person, and at some point you probably noticed that they did something well. Give me something. And had the case where the response is, well, she cooks real well, and that came out in court. Some clients you just can't prep enough.
Right. I had one time, I had a posting party one time in a case, said that the best quality that our client had was the fact that they were the biological parent of the client or of the child. That's it. Like they gave birth. They were part of the birthing process, right? That was the best quality. It didn't go well. Didn't go well for them. All right. I'll take a question if you want.
Okay. What can a parent demonstrate, or how can a parent demonstrate that they're acting in the child's best interest?
You know, when we're talking about the presentation, how you want to do that, right? What you want to do is you want to kind of look at, how are you, handling the child on a day-to-day basis. It's real basic, right? Be a good parent. That's pretty easy, right? Pick the kid up from school, or take the kid to school, to pick the kid up from school, take care of the basic needs, right? Food, shelter, love, that sort of stuff.
Not leaving them alone at home regularly and documenting it in text messages where the child says he or she is scared
Right.
and doesn't know where you are.
Yeah. The other thing,
It seems basic when we run through it, but I guess it's not super intuitive for everyone.
well, and I think the other thing is that parents can demonstrate that you're acting in the child's best interest by also making good decisions for the kid, right, or for the children, right? Making sure hey, the kiddo's got a medical issue, and so you're going to the appropriate doctors to get them the help or whatever's needed, or they're having issues in school, and you're making those decisions. And then lastly, quite frankly, and this is the one that I think is least intuitive, particularly in highly contested litigated cases, which is a parent can demonstrate that they're acting in the child's best interest by including the other parent.
Co-parenting is huge. Yeah.
By being a good co-parent. And being a good co-parent isn't making the decisions for the kids unilaterally. It's involving the other parent and kind of navigating that together. And that's difficult, right? It's a difficult concept, and it's a difficult sort of undertaking for clients for when we tell them, hey, look, I get your ex you don't like, right, for whatever reason, and you hired us, right, because you can't get along, right? You held yourself out in public that the two of you can't figure this out. But we really want you to go back to that person and start doing those things and start working on those things, because that's really how you demonstrate that you're a good co-parent, right? Or that you're acting in the kid's best interest, is that by co-parenting, or at least trying.
You
You've
put
got-
the
you've gotta
feelings
put it out-
aside
right.
and put the kids first, because the kids can feel it. They
Right.
see it. When you make the offhanded, snide comments about the other parent, that is so impactful for the kids. You have to think about the position that puts them in. They want the parent that is saying the negative things to be okay, and they want the other parent to be okay. It causes, loyalty issues, just a slew of concerns, obviously.
Here's another one. I think it's pretty basic, but what happens if both parents want primary custody?
Fight to the death.
Yeah, I think that's it. I think that's the situation. What we were talking about earlier, right? When you have two good parents, let's say they're two good parents and they're great parents, they just don't get along. They both want primary. They both. What is primary? Primary. You want the kids to live with you primarily, right?
We're assuming it's going to be joint custody,
Right.
and that the kids are going to primarily live with one parent, and the other parent then has a possession schedule,
Right.
whatever that looks like. The other parent then is also usually the one that pays child support, health insurance, all that stuff.
But ultimately, you got two parents want primary. The answer is, unless they agree otherwise, then you're going to litigate it, right? And so if you're going to litigate it, and that's what we talk about. You go in there. This is a best interest case. This is a Holly factor case, and you're just talking about two good parents and which one ultimately is going to give the children a better opportunity, and that's what the judge is going to make that decision based on.
In negotiations, you don't have to have a primary parent, right? So
Right.
primary really just means, like, if they're going to go to public school, that the kid's going to go to school based on that address. But I've done plenty of agreements where we say, okay, this term primary is really triggering for everyone, and everyone just really wants the W. Right? And to them, it means having that designation. We're taking it away from you guys. Like, what if we took it away and we said, here's the possession schedule, and the kid's school is going to be determined based on something else. So you guys have to agree. And if you can't agree, then we're literally going to look at the rankings of the schools, and we'll use the one that is higher ranked,
Right.
or whatever it is. But sometimes in cases where the parents really aren't going to be able to come to agreements on stuff, if you take some of that away and put in metrics for these, tiebreakers on those issues, whether it be a ranking or something else, it helps diffuse the situation, because it takes away those topics that are going to cause arguments.
No, I completely agree. If both parents want primary, then you should hire an attorney. That's the answer, right? You should hire an attorney and figure that out. All right, last one for me.
Ready? Can children have a say in custody arrangements in Texas?
Yeah, I mean, hypothetically, they can. The law says, hey, they're 12 years old. They get to go talk to the judge, and judge may or may not listen to them. This is all theater. All that stuff is theater at the end of the day. The law says that at the age of 12, you can a party can ask the judge to talk to the kids.
And if conservatorship is at issue, the judge has to talk to the kids.
Yeah, but here's the thing though. This is what happens when you've got people that Googled something. Right. This is you hear this as people Googled it, and AI or Google's research comes back and says, oh yeah, your kid can talk to the judge about what their preferences if they're the age of 12. By the way, they can also do it under the age of 12. By the way, just so you know.
And for me, when I have a lot, people have the misconception that the child gets to choose once they turn 12, and I don't know why that is, but that's
it's because they Googled it.
Google got it wrong.
Yeah, but no, I agree. Like for me, like the thing about it is, and what I think that there's a misconception, right, on social or not on social, but on the interwebs, right? That hey, yeah, that says that it can happen. Here, let's just talk about how it happens in reality. But then I'll give you a case real fast too, where it's just bananas. But in reality, the thing about it is, most of the time, most judges sort of loathe the idea of having to talk to kids. It's my understanding, right, that this is probably not their favorite part. Right. Talking to little Johnny or little Susie about, do you want to live with mommy or daddy? Right. And that sort of stuff. So they kind of loathe it. The other thing is too, most of the time, not all the time, and I'll tell you an example of this in a second, but most of the time, they're going to hear all the evidence ahead of time anyways. They're going to listen to the parties, do the full-blown hearing beforehand, and then go talk to the kid. The law says that the actual statute, the Texas Family Code, actually says that it's just a factor. It's not determinative. Right.
So it's just like all the other best interest stuff, right? It's one factor in the basket that the judge takes into consideration, but it's not supposed to be a determining factor or the determining factor.
Now, but that's not always the case.
Right.
The other thing is too, by the way, the judges may just tell you, no, I'm not talking to your kids. Sometimes they'll also just say, hey, I want to talk to your kids without you even asking. So it's fun.
That's real fun.
Yeah, that's real fun. But all right, so I'll tell you this case. I had this case. It was a long time ago, and it was in a smaller county outside of Travis County, and our client was mom and dad was opposing party, and we had one kiddo, and the kiddo was under 12, so we went to go have a temporary orders hearing. And we teed it all up, right? We did all the things, and we went to go do it. And we were trying to determine where the kid was going to live, with mom or dad. Mm-hmm. And so we announced, and the judge says, "Well, we've got here's your time announcements. Here's what we're going to do." And opposing counsel says, "Well, we have a motion to confer, and that's the vehicle, right? That's the request for the judge to talk to the kid." And kid wasn't 12 yet. So I said, well, kid's not 12 yet, and we'll still.
And this was on temporary orders, wasn't it?
Yeah, I think this was temporary orders.
And so the statute doesn't apply till final.
Right. Well, and the judge says, yeah, I'll talk to little Johnny. Yeah. And matter of fact, I want to talk to little Johnny before y'all put on any evidence or testimony, which a little odd, but sure, okay.
Now I know what case you're talking about.
Yeah. And I said, sure. So I told mom, go get little Johnny, and they roll little Johnny back there into the courtroom or into the judge's chambers. And we're standing out in the hallway, talking to my client and waiting. And I bet we're not in there 10 minutes. It's not been 10 minutes. And little Johnny comes out, and the judge says, y'all lawyers, come on back. So we go on the back there. We get in the back, and we're standing there, and the judge looks at both of us and says, well, little Johnny's got a girlfriend. And little Johnny doesn't want to move, so he's going to stay with dad.
Because of the girlfriend.
And I said, well, okay. Well, that sounds great. We still need to have a hearing.
Right. There's not actually been any evidence put on yet.
We're still going to have a hearing. And he says, well, if you have a hearing, I'm going to assess fees. I said, well, I appreciate that. Let me talk to my client. So I had
You
to go.
gotta love the threats from the judge.
So I had to go outside. I went outside and had to tell my client what little Johnny, one, had said, two, what the judge had said. And at the end of the day, we went home with no hearing, and little Johnny stayed with dad. My point of all that is this. You can Google whatever you want, and the statute can say whatever it wants. It goes back to the word we talked about earlier. It's discretion. The court has that discretion to do some things. More importantly, though, if what clients and what people need to know and understand is that you need someone to help you navigate these things. You need someone to help you navigate these things and be prepared for all sorts of situations that come down the line. And just because you Googled it doesn't make it the law. And just because it's the law doesn't mean that's what everyone's going to do that day. And so
you can have the law and the facts on your side, and it can blow up in the courtroom. Keeps it interesting for us, though, right?
It does. It makes it difficult to give expectations, but it's what we do. All right. That's it for today, I think. Let's do this. What'd you think about your drink?
It was really good.
Yeah.
Fernanda's crushing it.
Yeah, sort of my favorite. All right, guys, thank y'all so much today hanging out with us here at Cases of Cocktails. That's episode 6. We're looking forward to episode 7 coming down the line here. If make sure that you check us out. If you got any questions, don't hesitate to leave us questions as well. We'll pick those up in one of the next episodes we got coming down the line. So anyways, thanks so much.